If I could take the opportunity to call to order our criminal justice meeting, promptly 9 o'clock. Could I have a motion, please, to approve the minutes from the prior committee meeting? That motion is made by Supervisor Beatty, seconded by Super McDevitt. All those in favor?
Aye.
Opposed? Motion carries. Thank you. Our first order of business on the agenda this morning is to take a look at our Resolution 481 of 2013 and 27 of 2019. That is our Warren County Assigned Council Plan, and Mary has agreed to just give you a quick overview of what those changes are. She's highlighted the relevant changes in Section B of the resolution form number 20. Mary?
Yes. So just a little history on the Assigned Council Plan. The county first passed an Assigned Council Plan in 2013. I'm sure all of you remember the Harrell Herring settlement, which came about in about 16 or 17? 15. So based on that settlement, the county redid their entire Assigned Council Plan to meet the requirements under that settlement. I don't know if you remember, but the parties that were named in the lawsuit had to make those changes first. They were required by law. And then once those parties made the changes, the rest of us had to make the changes as well. But I think they implemented that for us like a year later. So based on that settlement, we changed our Assigned Council Plan. We brought it to this board in 2019, February of 2019. After this board passes this plan, it then has to get passed by the Bar Association, and then it has to get passed by the supervising judge. So we took the plan that this board passed, we sent it to the Bar Association, and they made some very small changes to the plan. If you look at your agenda on the second page, under details, it lays out for you the changes they made. In paragraph, all of these pertain to Section 5. In paragraph 4, they just added or assigned counsel. So they said in each assigned matter or assigned client. In Section 6, they just added as required by statute. Section 8, they just wanted to change meet to communicate with clients instead of making the assigned counsel go and actually meet with these clients. None of these are substantial changes. These are really just, in practice, this is how they do it more than what we put in our plan. The only thing that was semi-substantial is in paragraph 11. They wanted to require that the attorneys are part of the Bar Association. I don't really see that as a big deal. I know Joy wasn't super happy with it, but most of the attorneys are part of the Bar Association anyway, and the Bar Association has a professional standards committee, and they'd have to answer to that committee if they ever got in ethical trouble. So I don't really see it as a big deal. I know Joy didn't love it, but so now we bring this revised plan back to the board, and you have to pass it again if it's acceptable to you.
Questions? Supervisor Leggett?
Thank you, Ms. Chairwoman. On the required or the recommended on Joy's list of attorneys currently, are they all part of the bar already?
Yeah, so we went back and actually checked our Warren County website, and our website has been requiring them to be part of this Bar Association for as far back as we looked.
Okay.
So, I mean, they've already been implementing that.
Thank you.
Any other questions? Would anyone like to make a motion to approve this resolution? That motion is made by Supervisor Leggett, seconded by Supervisor McDevitt. Is there any discussion? All those in favor?
Aye.
Opposed? Motion carries. Thank you. Thank you to Amanda and to Joy for the last minute update on your resolution. We wanted to make sure that got on the agenda today, just to take 2 brief minutes and introduce to you Mr. Rob Gregor. Mr. Gregor, would you like to join us?
Back here. Sorry.
That's fine. Mr. Gregor is the new supervising attorney that you signed a contract in December of 2019 with, and I'll let him explain a little bit about his role and a quick introduction. Many of you are new on this committee, and so we thought it would be relevant for him to just introduce himself. Mr. Gregor.
Good morning, everybody, and thank you. My name's Rob Gregor. A little background on myself. I'm a 2007 magna cum laude graduate from Cornell Law School. During my 3rd year of law school, I had the opportunity to serve as a clinical intern in the Department of Justice as a prosecutor. At the same time, I also was doing death penalty work as a defender in the Western District of New York. That was my first real exposure to criminal justice and law. After graduating, after a brief career in a law firm life down in New York City, my wife and I relocated up here with our then 3-month-old son. And I started my own law practice shortly thereafter. In the 8 years or 9 years, I guess, now that have transpired, I've represented over 1,000 criminal clients, probably almost 1,000 family court matters, too, at this point. Done appellate work, made it all the way up to the Court of Appeals on a case, lost miserably 7-0 in that case. Guest lectured at Albany Law School, Cornell. I'm also an entrepreneur in residence at Cornell, and I currently serve on both the Essex County Assigned Counsel panel and the Washington County Assigned Counsel panel. I'm a former advisory board member to their council panel as well. And the reason I'm bothering you today is I'm the supervising attorney now in Warren County for the Assigned Counsel panel. A lot of people may not know what Assigned Counsel does or really understand what kind of our office is about. So that's one of the things I think I've been asked to explain today. If I'm correct, that's kind of my mandate today, as well as what my position is and my intentions are and that type of thing. So, if everyone doesn't mind indulging me for a second, just a really quick history lesson here. We're going to go back to 1961. We're going to go to Panama City, Florida. The Bay City pool hall just gets burglarized. Some pocket change, a bottle of wine, I think some cigarettes are stolen. Eyewitness says that a guy by the name of Clarence Gideon did the stealing. He saw him with pocket change, cigarettes, and wine. Mr. Gideon gets arrested for what in New York we would call a burglary. Florida had a different term for it, but same thing as what we call a burglary here in New York. Mr. Gideon goes in front of a court, says, "Your Honor, I'm poor, I have no money, I have virtually no education, I cannot proceed on my own, I need an attorney." The court says, "That's all well and good, Mr. Gideon, we feel for you, however, though, this is Florida, we only give attorneys to poor people for capital offenses. Unless you're charged with something that can basically take away your life, you're not getting free counsel." Mr. Gideon goes to trial. Predictably, he does lose a trial. Thereafter, he actually handwrites from his jail cell a petition to the United States Supreme Court and actually gets heard in front of the Supreme Court. The Supreme Court determines that under the Sixth Amendment of the United States Constitution, Mr. Gideon and anybody charged with a crime is entitled to counsel regardless of their ability to pay. Mr. Gideon actually gets retried. This time, he has counsel. Counsel cross-examines the cab driver. Counsel cross-examines the eyewitness, who turns out was a lookout actually in the burglary. Mr. Gideon is acquitted within an hour. He goes on, lives his life, dies of cancer, I think in 1972. Why did I tell this story? My job, my role in life, my mission in life is to make sure there are no more Clarence Gideons in this world. And that's the role of assigned counsel, that's the role of public defense. On a much more granular level in Warren County and other counties and beyond, what we do is we take applications from people who believe they cannot afford an attorney for criminal or family court matters. Review those applications to determine their eligibility. Do they financially qualify? We determine what, depending on the level of crime charged, depending on the type of act, whether it's family court, whether it's criminal, we try to fit an attorney who's qualified for those positions with that client, assuming they qualify. Thereafter, we process the vouchers and the bills from the attorney, and the cycle repeats itself again and again. I don't have the exact numbers, but I believe we opened in excess of 2,000 cases last year, but let's confirm that with Joy at some point. To give you an idea of just the volume that goes to this office. The office accepts applications right now Monday through Friday, 9 to 12. It's open Monday through Friday, 9 to 5 with staff. And then I guess the next question is, what does the supervising attorney do? So, my mandate is pretty broad. It's to improve the quality of indigent legal representation in Warren County and to also relieve the caseload and strains on the attorneys on that panel, or those panels in Warren County. How I do that that's really the kind of the meat of this. So, first and foremost, my job is to recruit and retain qualified attorneys on this panel. And when we say qualified, what we don't want is a situation, which is really what happened in Washington County, which is what led them to getting sued 6-7 years ago, which led to the Harrell Herring suit, is where attorneys were getting assigned to violent felonies, complex matters going to trial, who had never done a trial before, who had never really done much in the way of criminal work before. Again, the Constitution itself requires not only counsel, but the effective assistance of counsel, and that's key. That's really where the county liability is a concern. That's one of the reasons for hiring and what's come from it kind of taken effect. So number one is recruiting and retaining qualified attorneys. That includes, at this point, is interviewing other attorneys, everybody on our panel right now, determining who's qualified for which panels, which positions, who may need more training. Those that need more training, getting the continuing legal education materials. I'm sure everyone on this committee is aware that there's been a fair amount of changes in the New York criminal law within the last 30 days. We have the bail reform. We have the discovery reform. Not only does that change the statutes, but I would guess, and I look at my other lawyer colleagues in the criminal world here, I'm guessing in the next 2 years we're going to see a lot of case law coming down from the appellate divisions from the Court of Appeals interpreting these new laws. And that's going to make even more training for not only the district attorney's office, the public defender's office, but for my private attorneys. We've got to keep abreast of this to be able to deliver effective representation. All of us. Another step for me is taking the less qualified or less experienced attorneys and designing a mentorship program for them. Pairing these attorneys with more qualified attorneys, more experienced attorneys, and also putting together what's called a second chair program. So I'm sure people have seen trials on Law & Order on TV. Usually you have a couple of attorneys, sitting there. The second chair is kind of second in command. That person will generally be a less experienced attorney. It'll be an opportunity for him or her to learn, also to get a feel for picking a jury, and just get a sense of what that pressure in the courtroom is. And again, I look at my criminal defense colleagues here on both sides of the aisle. It's a different story once the jury's on, those eyes of the jury are on you. It's a different sort of adrenaline rush. Another area that I'm tasked with is on reviewing the vouchers. So the bills that the attorneys submit, making sure there's no overbilling, making sure the county's getting their money worth. Another area which we've really started working on, I'm getting excited about, is identifying and procuring different services which may be at the state level, which won't cost the county taxpayers any money, but delivering that. One example is a Veterans Defense Program. The New York State Defenders Association essentially runs a program for anybody who's served in the military, regardless of length of service, level of discharge, branch of service, dates of service, that they'll provide free what's called mitigation expertise. So explain to a court, someone charged with a crime, that post-traumatic stress disorder may affect somebody differently in a certain situation. Now, these are services right now that if I had to apply for, I would apply to the county. I would seek a letter from the court giving me $1,000 or $500, and it would come out of the county treasurer's office. The services that we've now found, the exact identical services, will be done for free. It will take money off the county taxpayers' budgets, ideally. And in that sense, I think there's other areas of other efficiencies that we can get to with respect to the budget process that will save our county taxpayers money, and also enhance and improve the quality of representation. So I thank you for indulging me and for letting me bore you with legal history and everything else that I kind of love to talk about. I'm going to end with the happy note on this. Everything that I've described in the sense of the supervising attorney salary, in the second chair program, in the mentorship program, does not cost the county one dime. This is all funded by grants from the Office of Indigent Legal Services. There's no matching. There's no, in lieu of payments or whatever other normal grant structures are. This essentially is money that comes right from the state and funds these different programs. As I said earlier, it's meant to make sure that there's never another Clarence Gideon out there. So I'll take questions if anybody has questions, or I'll stop worrying you if you want me to stop worrying you.
Thank you, Mr. Gregor. I know you have a court appearance as well.
I do, yes.
Mr. Moore, did you have a question?
I just wanted to see if you could speak to the reason why we have to have somebody in your position with a law degree, in terms of the new mandates from the state.
Certainly. So there's a fair amount of money that's coming from the state that we just discussed. And there's essentially two ways that it can be done. Almost every county has or will have an assigned counsel program. That will have an administrator. The administrator, if that administrator is not an attorney, the state wants an attorney to kind of ride alongside that administrator to focus more on the legal end of things. Whereas an administrator may be more qualified for the budgeting end of things, for the financial end of things, for the implementation end of things. They're really less qualified to discuss, well, how does the discovery reform affect the defense community? Or in a trial situation, is a justification defense going to work here? So my job is much more to put my decade-plus years of experience in this profession and assist the attorneys, and also act as a liaison with the state in that sense, too.
Thank you.
that
That answer your
satisfactory?
question?
It does, thank you.
Mr. Gregor, I certainly appreciate the time you took to speak with me this week, but also the expertise and your leadership that you bring to the table. I think we all, as county elected supervisors, care a deep amount about justice within the criminal justice system and want to continue to move forward to help in any respect that we can. I know that it's a busy season for Joy right now, and unfortunately, or a busy time. She wasn't able to make it this morning, but she did want to invite any new supervisors to please reach out to her that are new to the committee, go in, see what's going on and ask her any questions. Did anyone have a brief question for Mr. Gregor before he has to get to court? No?
I'm available anytime. You can call down to the assigned counsel, or I can also get you my private number. Feel free to call. As you can tell, I'm pretty passionate about the work that I do. I'm very lucky to, in this community, also have people like Ms. Flores and Mr. Carazone working kind of as part of this. I've worked with them for years, and it's a great team to be a part of, so thank you.
Thank you. Supervisor Leggett?
Yeah, just one question, because there are new members here, and how assigned counsel works with public defender. Who gets what and where is assigned counsel?
Very, very good question. So the way to think of it is this: the public defender's office is, if you're indigent and you're accused of a crime, or if there's a family court matter, you're the first stop shop. They are a team of attorneys that are employed by the county. Once there's a conflict of interest that they may have, not in any sort of a negative way, but sort of a perfect example being one of their clients may be a victim in a crime. So they can't represent also the defendant accused of that crime. That's when assigned counsel comes in. So we handle any conflicts, any times there's co-defendants. In family court, if you have two parties adverse to each other, the public defender's office wouldn't be able to handle both ethically. Not suggesting anything's unethical, but that the ethical boundaries don't allow us to handle two adverse parties at once. So that would get assigned out to assigned counsel.
Thank you.
Thank you very much for your time this morning.
Have a great day, everyone. Not to be rude, I'm going to leave, but I've got to get to Washington County.
Good. Then moves on to any referral or pending items, which we do not have any, or any information for discussion and review. Privilege of the floor at this time. Anyone would like to address the criminal justice? No? All right. Could I have a motion to adjourn if there's nothing else?
We have
What
the
do I need?
public defender.
Oh, thanks. Sorry. I was going to close. Apologize. All right. We're done with public defender. We're done with assigned counsel. So Marcy, I appreciate your flexibility this morning to move on then to the public defender's office. Well, first let me just ask for a motion to approve the minutes of the prior. Do I need to do that for public defender? I'm out of practice. Okay. So I wanted to express my gratitude and appreciation to both our district attorney and our sheriff's office and probation for a last-minute revision in just light of the fact that we didn't have the DA or probation on the agenda for a bail reform update. Supervisor Leggett, as the prior chair of criminal justice, was nice enough to agree moving forward. What we will try to do is make criminal justice and public safety meet on the same day together, so we aren't asking our sheriff's office to come back for a quick bail update on different days. So this morning, Marcy agreed to just let us have a quick update by our sheriff's office and our DA's office. This committee, criminal justice, will be the committee to report on bail reform just generally, and we're going to keep that as an ongoing agenda item until such time that we don't need to keep updating our committee on it, which I'm not sure if we see that in the foreseeable future. But Jason or Terry is here. We appreciate it under Sheriff Cuomo, and Director Bob Usey with the Probation Department. I don't know if the committee has any questions, or perhaps Jason, if you can just, I know it's an area that's going to continue to need financial resources and legislation, so we wanted to make sure we brought it to your attention.
I don't know if this is on. I'll speak up. I don't think it is. Thank you. So I know most of the people in this room. I'm the district attorney of Warren County. I won't go into, I didn't graduate magna cum laude, I got to admit. I started at ACC, which was great. And at any rate, we've been in the criminal justice system. I personally have been in the DA's office 20 plus years, and I actually did assigned counsel work before that, so family court criminal matters, before there was a public defender's office. And I started at the DA's office and Marcy Flores was there, so we go back a long way. The things radically changed in the spring of 2019 when the state passed new laws. And I remember, leading up to that, there had been a lot of discussion. I'm a part of the District Attorneys Association of New York, and that's a group that gathers twice a year we have a legislative committee, we have groups that try to talk about these things. And we were hearing the rumblings, and I personally went and met with some people in advance of these laws passing, and I think the people I met with didn't support those changes, but the changes have occurred. Since April, we as an office have had to essentially completely rewrite what we're doing day to day. We've been having a weekly staff meeting, which frankly has never happened before because you just don't have time. I was already in the process of digitizing, but that went from trickle to massive acceleration. All of that requires resources, training. I didn't realize the effort involved. So the first thing I would say is that the people that work in the Warren County DA's office gave it their all and are continuing to do that. I'm in on the weekends. I saw Marcy's car on Martin Luther King's holiday here. Everybody's working very hard. These new laws, so bail reform is what we hear about, bail reform. I would suggest we say criminal justice reform because the entire criminal justice system has been radically altered from what it was. And why that's important is it's going to have an impact on policing, it's going to have an impact on being a prosecutor, and I would think it'll have an impact on defense as well. So just to touch on bail, and I know people have probably read about it, heard stories, and a lot of the things that I think people connect with is bail. You hear, wait a minute, why is that? So what I thought is I'd give an example of something very small that isn't so outrageous as for example. Queensbury, we get petty larcenies are very common. You'll see petty larceny is a very common thing. Petty larceny is stealing something. It could be worth $1, it could be worth $999. It's all petty larceny. Currently, if some kid from Queensbury goes to Dick's Sporting Goods and steals shoelaces because he thinks they look cool, and he's always lived here and he has no criminal history, he'd be charged with petty larceny. And at the same time, if someone drove from New Jersey and went to the outlets and stole $999 of stuff, they'd be charged with petty larceny. The person at the outlets, let's say that you looked at their criminal history and they had a history of bail jumping, they had a history of warrants for not appearing in court, they had a prior felony conviction for stealing, let's say you had all that. Under the new law, the judge must do the identical thing with both of them. There's no discretion. Doesn't have a choice. He or she can't consider factors. And I'm picking petty larceny because because what we've been hearing is, look, these are low-level crimes, and look, I'm not even going to say fair and unfair, but discretion is removed. That very same judge has discretion in sentencing, in putting someone in jail. They have discretion at hearings. They have discretions during jury selection. They can do a bench trial and have discretion on whether someone's guilty of a crime, but they no longer have discretion, and that's on a petty larceny. Where I think more people are surprised is when they start hearing those bigger crimes. Manslaughter, criminally negligent homicide, burglary of a dwelling, even if it's occupied at the time, robbery, making a terroristic threat, and the list really goes on. Criminal obstruction of breathing, assaults in the third degree. There's a very expansive list where the court, in the same scenarios I said with petty larceny, has no discretion to set bail. So I think we're all aware of that, and my concern is when you strip away discretion from those who, we heard Rob Gregor's background, very bright guy, a lot of education, a lot of experience. Let's say he were a judge. That's gone now. His experience and his discretion is removed in most cases. What's going to have the most profound impact, and it already is really the discovery reform. So I think that's a thing that's much harder to connect with when you hear it, but there are certain things that people are connecting with. Under the new law, when someone's arraigned, the prosecution has 15 days to supply a complete file, which sounds great, right? Like, we'll just pick up your file and hand the file to the defense and you've done. But that's not how files come. That's not what it means. That's not what a file means. If there's an indictment, that also means a grand jury transcript, which means a stenographer, which means they have to do the grand jury work and do the transcripts within a certain time frame. We then have to digitize so we can disclose. If there's medical records, which there often are, we have to go through, and I've got a case right now, and the medical records might be this high. We have to go through and try to redact social security numbers, tax ID, any kind of identifier. We might need to do protective orders. This is all in that 2 weeks. This is every single criminal case, no matter what. And non-criminal, frankly, harassment, disorderly conduct, you name it, that's the new standard. We have to provide a list of any witness that may have relevant information. Then we have to have their criminal history. So I have a case where that list is over 100 people. So now we have to run 100 criminal histories. The DCJS does not permit us to disclose criminal histories. So now we have to go in the criminal history and create a new document and sort out and build a new crime, or the conviction portion, for disclosure. That's all in that 2-week period. Lab reports. The lab doesn't get lab reports in 2 weeks. They also have to do what's called a Rosario Disclosure. So as I'm explaining this because it is absolutely overwhelming. It is extremely burdensome. I can tell you that many defense attorneys are doing what they did in the past, which is, well, I'm going to waive time frames. I want to talk about the case, and I know you're going to get me this stuff. And that's been helpful. We work in a collegial setting, and I think, from my perspective, there's a lot of sense to that. We see that last year. Someone's charged with a felony. Defense may say, look, I'm going to waive your 30-30 time and your 180-80 time. Let's talk first. Sometimes we talk and we resolve. Sometimes we talk and we don't. And then they go, all right, well, I'm withdrawing those waivers and we're moving forward. I don't want to go on too long because I'm being slipped in here, and I already have. So at any rate, bail reform has really made it to the forefront. I think the public's aware of it now. The discovery reform also has a huge impact. If you're the victim of a crime, your name, your contact information is supposed to be given over in those 2 weeks. If you're a witness to a crime, your name and your contact information is and your criminal history is supposed to be turned over. If you're, and you've seen this in the news, if you're a firefighter, if someone goes to the hospital and EMS drives them there, they might be a witness. And then a nurse treats, then another nurse treats, then they pass them on to a doctor. Those are criminal histories that would need to be run, contact that would need to be disclosed. So you can see the sort of massive nature of all this. I'll stop. Any questions?
I certainly appreciate the time you took to come this morning and address the committee. And before I ask if there's questions from the committee or other supervisors, Under Sheriff, was there anything, we certainly appreciate you coming this morning. I know we'll hear more about it Friday, but I didn't know if there was anything you wanted to add.
I won't be as long as Jason does. We have currently this morning at 5 a.m. we had 80 inmates in our population. And we've had 8 since January 1st released on criminal justice reform. So we are keeping track of that on a daily basis, and we will report that in our committee meeting. And we have a few. We have 2 full-time folks, a patrol sergeant and a communications officer, that are busy. You don't get much of a chance. Our sergeant, he's working very hard to get all that paperwork in and get it to Jason in a timely manner. And I think right now it's working. It's a slower time of year, but we may need to ramp that up in the summertime when we get a little bit busier.
Thank you. And as we can see, it's certainly a collaborative effort. We'll be hearing from our public defender's office. But Director Yusi, is there, from the probation side, I know it can have implications on your office as well, and I certainly don't want to leave you out. It's a critical part of this impact to our community.
No, thank you. I'll be brief. My world's not as complicated as Jason's in the attorney's world, but nevertheless, probation, as we've talked about through the past year, is the pretrial agency within the county. We've operated a pretrial release program for 30 years in the county in a structured manner. This law has changed the structured manner. Recently, I think it was on Christmas Eve, we were notified by OCA that we are temporarily approved as the certified pretrial agency in Warren County for whatever temporary means. There's really been no clarification from OCA, and through the year, through this last year, there's been no direction from the Office of Court Administration, no guidance. So we've basically been here to act on our own. But what I can tell you I think, which is important. The things that we saw important out of this legislation was the notification of defendants and the individuals that would report to us under RUS. Jason talked about these crimes and these individuals that no longer bail us set. When they're released to my department. So it's our responsibility to supervise them. Since January 1, we picked up 15 RUS cases, and to date we have 50. That's a little more than we're used to dealing with. It's early, we're only 22 days into the year, so we'll see what that means. I think the good things that have happened was the Office of Court Administration assumed notification responsibility of defendants. And when I say that, the law indicates that an individual is supposed to be advised of their court date by email, text, phone, letter, whatever method they prefer on every court date. In Warren County, I don't have the numbers, but that's probably thousands of cases. And at the time, if that was our responsibility, that would have been something that's just something you can't do. OCA indicated they're going to take responsibility for notification. We really haven't seen their plan. We don't know for how long, but for now they are. So for now we're good, and we'll see what the year brings. So we do have the infrastructure to deal with pretrial. We've been doing it for many years. So far, it's fine. We'll see what the year brings. In my department, in my world, we're used to adapting to poorly crafted laws. We've been dealing with Raise the Age for the last 2 years. We go back 10 years ago to ignition interlock, and these are well-intended laws that have a lot of unintended consequences because they're simply rushed, and there's not a lot of information. One interesting thing, when we interview people, we used to interview people in jail who couldn't get out for lack of bail. We used to use a risk assessment tool we've used for many years. In New York, the law says you have to have a validated risk assessment tool. The instrument we use is not validated in New York. There's only about 2. There's one in New York, run by the Criminal Justice Agency, and there's one in Monroe County, and then I believe there's another in Niagara. So the rest of us do not have a validated risk assessment instrument to interview people with qualifying offenses, to give information to court. Why is that important? Everybody likes information when they make decisions. So judges like to know what's the failure to appear, what's their criminal history, what's your contact with them, and those type of things. We've had one request by a court to do an interview. We indicated to the court we do not have a risk assessment tool, but we were able to give that court some information because that's important, and we have a good relationship with the court. So in sum, so far we're managing. We'll see what the numbers look like, and we'll adapt. So, any questions?
Thank you. I think this morning what you're hearing is that all-inclusive multidisciplinary effort, and so given that overview, and I thank you all for coming, are there any questions from committee members? Supervisor McDevitt.
For Terry, maybe the 8 inmates that were released recently, just not to get into specifics, but just in general terms, people, minor stuff, and with the biggest issue being the fact that this person just may disappear into the woodwork. I mean,
well, there's always that concern that somebody would disappear into the woodwork. There has been some news releases on folks that don't have U.S. citizenship, that type of thing, and it's a really right now a wait and see game. It's a release because we're following the law, and we'll see where it goes from there.
okay. Thank you.
Peter, to follow up on that, 5 of the 15 we had were released from county court. Those are felony cases. Bail was set prior to January 1. After January 1, Judge Hall released them to our supervision. They're typically B felony drug offenders, so not petty larceny. So they do report to us.
And a D felony is?
B felony.
B?
B. Jason can talk. That's a pretty serious crime.
A is the highest, then B. Okay, well, that sounds pretty high.
Yeah, so many of the releases are felony level offenses. So the court structured the release of basically, I'm setting bail now because I think it's appropriate, but the law doesn't permit me to come January 1, so you will be released. And as Terry said, we don't know what's going to happen. No one really knows. There's an essence of completely revamp all the laws at the same time, there's no judicial rulings, there's no legal precedent, so everything's a bit of a guessing game in all aspects. Marcy may have an opinion, I may have a different opinion, the judge in Warren County may have a third opinion, and then that's going to have to go through your appeals process. I think the thing that should be noted is many of our judges were doing the release in advance of January 1. So the January 1 numbers don't look all that radical. That had already been happening for months. Not every judge was doing it, but many, if not most, were. So all small level things weren't having bail set in the month preceding January 1.
One last question. What would somebody have to do to get charged with a B felony?
A B felony, if you sold heroin on the street, if you possessed a large quantity of heroin or a large quantity of crack cocaine. You also can't set bail on A felony drug cases. There's almost no drug case can have justice, only one. That, I don't know if it's ever been charged in Warren County, which is operating as a major drug trafficker with a profit of more than $75,000. So that's an example of crime that we see, and a lot of the people that we see accused of the crime aren't tied to this community. They may be heading to Vermont, they may be coming here, they may be from another state. It's not uncommon.
Any other questions? Supervisor Beatty?
Yeah, obviously this bill reform law is very disturbing on a number of levels. Although maybe well-intended in its original concept, the unintended consequences are devastating to the safety of this population. And quite frankly, I'm not the first voice on this. There's numerous voices. In fact, Sheriff from Washington County, Murphy, has 120,000 online signatures protesting and opposing this law. When you don't give a judge the ability to use their experience and expertise is appalling to me. When you don't give the ability to allow, when you give the ability to allow a terrorist to walk off the street who threatens to blow up a building, I'm speechless. And so anyone who doesn't think this needs significant reform and or maybe totally appealed and start over fresh with all the players having a stake in it, sheriff's departments, the DAs across the state, the public defenders across the state, having them all a seat at the table so that we can craft some type of meaningful reform law is just not using any common sense. So I applaud the fact that, I know everyone has a little different takes on this coming from where they are. Probation, the DA, public defense, but I hope we can all come to an agreement that it needs some type of reform, if not appeal, totally being appealed, and repealed, excuse me, not appealed, repealed. And going forward, I know this county sent a resolution last month denouncing pretty much this new law. I know it was softened up by some. I didn't want it to be softened up. I think we need to send a strong message. But I thank you for your input and keeping us updated on this. We've got, and hopefully, Mr. Chairman, you'll have them come monthly to give us just a brief update.
Well, I think Jason framed it correctly in terms of criminal justice reform, and we'll keep that as a pending agenda item to the extent, there's those updates. Supervisor Leggett?
Well, any word from the public defender on criminal
She's coming.
justice affairs?
She's up next. But so we'll ask Marcy to join us, and again, thank you. We recognize how busy you are to take the time to give us that update and to be our voice as legislators and to continue to fight for our entire criminal justice system.
Thank you. Is it all right if I...
Yes, please go. That's what I mean. Both the under sheriff and probate, of course. Thank you.
Can I go back to sitting here? Is that easier?
Please do, Marcy.
Thank you. Okay.
Bye. Thanks, Jason.
It's okay. I'm all good with it. I'm fine.
Thank you.
I also did not graduate magna cum laude from law school, okay? I went to Emory Law School in Atlanta, Georgia. So those who don't know my background, I'll give you a real quick version. I started in the Suffolk County District Attorney's Office. I was there for 11 years doing organized crime, white-collar crime, and a supervisor of the District Court Bureau, which handled 150,000 cases a year, which is misdemeanors and violations, supervising 46 secretaries, 25 attorneys, 10 crime victim advocates, detective investigators, and other support services. And there were 13 judges in the District Court Bureau that I had to deal with in addition to all my attorneys. So that was my criminal background before moving up here. Moved up here, worked in the DA's office here for 8 years. I was the coordinating assistant district attorney here, then went into private practice with a former DA, and then we created the public defender's office in 2004. And so I've been practicing criminal defense for 37 years. So I'm not new at this. So that's my short background of why I'm where I am here. In terms of the bail reform and the new laws, Jason and I didn't draft it, because if we drafted it, it would be user-friendly because we understand how the system works. I am stuck with the law as it is written, and I have to apply that because that's what New York requires. So that's the shortest version I can give you in terms of that from my perspective. I would like to hit my agenda items if you don't mind, because I think we may be running over time-wise. My first one is Lynn Pucciarelli, who was my third assistant. She left. She became the law clerk for Tatiana Coppinger, who is the Hamilton County judge. So she left at the end of this December. So I'm looking to fill her position, which is vacant position number 3. The salary is $69,891. That takes us back to the salary grid that was set up last year, so that's the bottom level for that position. And I'd respectfully request that you would grant me permission to fill that, because I need a body.
That is moved by Supervisor Leggett, seconded by Supervisor Driscoll. All those in favor?
Aye.
Opposed? That motion carries. Thank you.
Thank you. Next one, legal clerk. You gave me permission under Office of Indigent Legal Services funding to hire a legal clerk. I have gotten applications in. I would like to make an offer to someone today, subject to your approval. The position is contingent upon Indigent Legal Services funding continuing. We haven't had any problems with that, but the person is aware that if they are hired and the funds leave from the state, that person no longer has a job. No county funding matching from the county. It's all straight Indigent Legal Services. So I would like permission to hire there.
Motion is moved by Supervisor Shepler. Is there a second? That is seconded by Supervisor McDevitt. Any discussion? Supervisor Beatty?
Is that funded, 100% funded by the state?
Yes, 100% funded by Office of Indigent Legal Services.
All right, thanks. Yep.
All those in favor?
Aye.
Opposed? That motion carries. Thank you.
Okay, thank you. Next one, coordinating assistant public defender. It is a new position. It would be funded fully by Office of Indigent Legal Services. It is a supervisory position. The purpose of that person is to help me train the younger attorneys. Last year I had 3 brand new attorneys who were admitted last year come start at my office, so I'm bottom heavy in terms of that. So having an attorney with experience would be important for me to have. The salary that is to be determined, it is a range of $72,074 to $92,623. That's what we have grant funded, fully grant funded, no county matching for. I understand on the salary grid it even goes up to 125. Certainly I'm not encumbering this county to pay for things that I can't afford. So if it's not in the grant, we don't get to hire for that salary amount. So I'm telling you right now, the salary will be only within what the grants will allow us to pay, no matching from the county. And it's a new position. Yes, sir.
Just to clarify, this position was created in the 2020 budget. It's already in the compensation schedule at the $94,000 and change salary that Marcy stated. When we hire somebody for this person, if we need to adjust that salary down commensurate with that person's experience, we'll do that, and we'll bring it back to the board for an amendment to the comp schedule.
Yes. Thank you. Are you making a motion, or you have a
No,
question?
just a question, then I'll make a motion.
Sure.
Thank you. When you say supervising attorney, are they going to be in court, or are they just...
Oh, yes. They're
so
going to
they'll
be in court.
So.
You know, when Jason was talking about having a second seat, well,
Okay.
this attorney would be the first seat, helping the
Okay.
new attorney the
Okay.
second
Thank you
seat.
for
In
clarification.
addition, they'd be helping them work up their cases, because you can't just go to trial and
Right,
start there.
okay.
You need to do the whole process.
Appreciate it. Thank you.
Yes, Mary.
So I just want to clarify, since this position was created as part of the budget, the only thing that you need to do is authorize her to fill the vacancy. So
Okay,
it's not creating,
so
it's just filling.
request to fill.
So we still need a resolution?
Yes.
for that. Okay. Any other questions?
Um,
Yes, Supervisor Leggett?
Thank you, Chairman. Is this in addition then to your whole roster of
Yes, this would be,
attorneys?
yes, sir. it
Like the
would be.
ninth position?
Ninth is also going to be addition. I'm not up to that one. I'm only up to the coordinating.
Okay.
But the coordinating is a higher position than the ninth.
Okay.
It's higher, it could be higher than the first assistant in terms of experience level and whatnot, depending on who I get. I have some people who are interested, but certainly I needed permission before I can go forward.
Thank you.
Thank you. Is there a motion? Anyone like to make?
I'll make the motion.
Thank you. Supervisor Driscoll, seconded by Supervisor Leggett. Was that your, all those in favor? Or is there any
Aye.
further discussion? I apologize. I should have asked. No? All those in favor?
Aye.
Opposed? That motion carries. Thank you.
Okay, that takes me to request to fill a new position, number 9. Again, it's a mid-level attorney position in the office, not a baby, not a supervisor. The salary is indicated as $71,931, and that's within the salary grid. Again, it's fully funded grant position. It is subject to, if the grant funding goes away, then the position goes away. No matching from the county.
Any questions? No? Anyone like to make a motion to create, to create that position? The motion is made by Supervisor McDevitt, seconded by Supervisor Shepler. And Mr. Moore?
As Marcy, in creating this position, the goal is to get the caseloads down to standard, is that right?
Yes, it is, correct, because we're above standard.
Which the state has set those standards.
And I think that Mr. Gregor talked about that earlier, so I
Right.
don't want to repeat all of it.
Any further discussion? All those in favor?
Aye.
Opposed? Motion carries. Thank you.
Next one is amending the existing contract for Lexisnexis. Lexisnexis is a search engine that the attorneys use to do legal research. We have a contract that says I have 7 assistants and myself, and those are the only people who can use that system. Well, I now have more attorneys, so the purpose is to amend the contract to allow us to allow these other attorneys to use the system too, because I'm not violating the law by doing things we're not supposed to do. So that's the purpose of this. Now, the funding in terms of this is the county pays X amount, which is what the number is it's always done. Anything additional is paid by Office of Indigent Legal Services. So it is not county matching. It is any additional funds that I need for this is going to be paid by Indigent Legal Services.
County Attorney?
I'm sorry, so we currently have a contract for,
7 plus me.
$358.67 per month.
Right.
So the contract is going to stay the same, or we need to change it?
The contract is going to stay the same, but because of more attorneys, it goes up.
To
Increase the amount.
I can get you all the paperwork. I thought I had sent that to you before on everything from IOL.
Yeah, so we
And
need
from-
to, the email you sent me has the price going up to $548.
I think that's the next year's contract goes up.
So we do have to amend the contract for that increased amount.
When that happens, when I have more, yes. And my position has always been whatever search engine the county wants us to use, I will use, whether it's Westlaw, Lexis, I don't care. I just need a search engine to do research. And I know that the county in the past has worked with Lexis to work out reduced costs. So I think these were consistent with those things that have been going on in the past.
Any other questions regarding this? No? Is there a motion to approve? To make the resolution? It's moved by Supervisor Leggett, seconded by Supervisor McDevitt. Any discussion? All those in favor?
Aye.
Opposed? Motion carries. Thank you.
Okay. Next one, request for a new contract mentoring services. Rob Gregor talked about this also. When you have attorneys come in from outside offices or outside practices, and let's say I have a case that requires a certain expertise, and there's a defense attorney who's out in the community who does that kind of work, and we don't have the expertise for it. So the mentor contract is for specific services for specific hours to mentor a specific attorney on specific things. It is not a daily basis. It is not a weekly basis. It's as needed basis. It's not a lot of money. I think it's $4,000. So it's, you know, for the years, which is not a lot. But again, we have to set up the individual contracts and with that specific attorney for however many hours we're going to actually need to use them. And it could be multiple attorneys doing it, depending on what the type of case is. An assault case is different than a white-collar case.
Supervisor
Thank you,
Driscoll.
And as I understand from reading it, it's the same per hour rate
Right.
or whatever
Correct.
the specialty is.
Right, and I know Mr. Gregor, I'm sure, is using the same rates for the
thanks.
assigned counsel office.
Any other questions? Supervisor
So
Driscoll.
there's no contract right now, this is just permission to go for, we don't have...
Right, and I'm
facts
working
and
with the
figures
county
in front
attorney's
of us.
office to get that drafted, but I wanted to make sure, going through here, that you'll allow that to happen, but it will be specific, and the county attorney's office would absolutely be handling that piece.
Sorry, I missed it, and this is paid for,
Office of Indigent Legal Services, no matching funds from the county, no county funding.
Will that contract need to come back to committee, or upon approval of this, then the county attorney's office proceeds?
Yeah, so basically what the committee is approving right now is just a contract for mentoring services. You don't know with who, you don't know the term, and you don't know the cost of it right now. But if it goes through like this, it will not come back to committee.
Well, we know the cap on it.
Yes.
It will not exceed the $4,500, whatever it might be.
Yeah,
It's a
the
relatively small
budget
amount.
line that we
Yep.
have, it cannot go a penny over of that, and it will not.
And those that you contract with would be specialists within that area
Yes.
of expertise that you would
Yes.
need.
So we are adding a not to exceed, because that's not part of the motion right
The,
now.
my concern is that if Indigent Legal Services on the Harrell Herring, this 5-year grant that we're in right now, so we're in year 1, we're already starting year 2, we don't have the contract for year 2 yet, but for the funds, if we don't use it in year 1, can go into year 2. So I'm concerned about putting the word cap in it, because I can use year 1 funds to pay year 2, 3, 4, 5 as they come about. Does that make sense? Or did I get that too confusing?
When does the rollover stop?
It doesn't, it's all 5 years.
On Harrell Herring?
On Harrell Herring, it's a 5-year rollover. It is not, our other contracts that we've had before are called distribution and grants, okay, before the 5-year Harrell Herring. And the 5-year Harrell Herring, I don't have to go back and reapply every year, versus the grants and distributions before, we had to apply every year for extensions. So it's a different setup.
And
It's a 5-year now.
the distributions are where the extensions are stopping?
Correct.
Okay, gotcha.
Yes.
Other questions regarding this?
Can I just add one other thing? For those who are new to dealing with me on this issue, we have had over 10 grants and distributions plus the Harrell Herring settlement. So there's a lot of money coming in from different pieces. They all have different timeframes and what they're used for. And so Erin Brothers, who is our data officer for Office of Indigent Legal Services, who works in my office, she handles all the grant paperwork and the distribution paperwork and deals with the treasurer's office and ILS and makes these things happen. So that becomes very important, you know, that we're pulling from different pieces so that we don't have the county spending any money on this stuff.
Pleasure of the committee. Mr. Moore?
Just a clarification. I want to make sure I understand this. We're hiring outside attorneys to provide mentor services. We are, in terms of, for purposes of that contract, we're putting a dollar amount not to
Yes.
exceed on the contract,
Right.
regardless of which year the funding comes from.
Okay,
So
that's-
what,
yes.
is that correct?
Yes. Tammy.
It's an hourly rate.
It's an hourly rate.
Of
What?
$150 per hour.
$150 an hour, and are we putting a cap on the hours?
No, I would not be requesting that, because what if one case needed more time than another? Because I could pull it from different grants.
So what you're proposing is, as long as you'll keep it under the funding, but if the funding should go up from $4,500 to something else and you have a need for it, that you'll use the funding?
Yes, that would be great.
Supervisor Driscoll, then our county
Thank you,
attorney.
Madam Chairman.
Thank you, Tammy.
But as I understand it also, that the regulations with Harrell Herring are pretty specific. So I mean, the worst case scenario is that you might need to employ specialists, and you could, again, the worst case scenario, exceed that threshold if necessary.
I hear what you're saying. At this point in time, I do not see a need for that whatsoever, and certainly because I would not encumber the county's finances without permission from the committee. I will not be doing that unless I come back to the committee for a specific issue.
Right.
Okay? Just, I want to make
Yeah.
that clear.
Sure. Yeah, as long as it's covered.
Mary, did you want to?
Is the $150 an hour, is that a set price? Could we put
Yes.
that in the resolution?
Yes,
Okay.
it is. Thank you.
Any other questions? Anyone like to make a motion? That motion is made by Supervisor Driscoll, seconded by Supervisor Shepler. Any further discussion? All those in favor?
Aye.
Opposed? Thank you, that motion carries.
Okay, last two are out-of-state travel authorization. Brian Plasky wants to go to a National Defenders Association. It is down in Charlotte. Everything would be covered by Office of Indigent Legal Services. The county has no matching funds, no any expenses whatsoever. It is a conference that deals with a lot of intensive continuing legal education classes that are for experienced attorneys. It is not a baby course. It is an experienced attorney. Mr. Pulaski has tried attempted murder cases in another county, so he comes in with a great deal of experience, and he's been practicing for over 10 years. So that's why that one becomes very important for us.
Questions? Is there a motion to approve? That motion is made by Supervisor McDevitt, seconded by Supervisor Leggett. Discussion? All those in favor?
Aye.
Opposed? That motion carries. Thank you.
Okay, last one on the request is a request for me to travel in April to Las Vegas on a scientific forensic and the law. It is an intense few days CLE in very scientific pieces that I don't have the experience in yet, and quite frankly, I feel that I need. Again, it's all paid by Office of Indigent Legal Services, no county matching, just straight from the IRS.
Thank you. Marcy and I had a chance to talk about this. I fully support it. I'm wondering if there's a motion to approve it. Made by Supervisor Leggett, seconded by Supervisor Shepler. All those in favor?
Aye.
Opposed? That motion carries. Thank you.
Can I just add one or two things? One, I want to thank you all for allowing me to use the ILS grant, the Indigent Legal Services grant, to hire a case manager. He starts on February 3rd. The reason why this is so important for my office is, having done prosecution and defense for years, I feel that we have to look at society and the community and what to do with clients, because if they're coming back into the system repeatedly, there's got to get a way to get them out of the system. I believe in a holistic method, and that's where my office is heading to, which means you deal more with dealing with the person. So the case manager piece requires the case manager to make sure if a court is imposing something for a client to do as a condition before a plea or after a plea, community service, substance abuse, mental health, trying to get somebody out of the jail into a treatment facility, that person is going to help coordinate for our office. Because right now, every time I have to get medical records from a client, I have to draft the HIPAA, I have to get it to the client, I have to follow up on it. And it's spending time doing non-legal work that the case manager could do. And in addition, the case manager that we have hired has ties to the community and already works in the system with mental health and substance abuse. So to me, it's a really big win for my office and helping all our clients. One of the other things that I do is I sit on different committees, obviously with the board's permission, and one of them is like a community policing approach. It is, I call it Law Enforcement Luncheon Mental Health. It's been going on for over a year. It's with Warren Washington Association of Mental Health. It was an outshoot of the SIM project that occurred about 2 to 3 years ago, where you have law enforcement, mental health, substance abuse, DA, public defense, and for Warren Washington County, it's a bi-county committee, meets every month. And I think it's an important committee because we're trying to come up with some alternative leads to do things differently and try to be creative approaching. So I understand my clients often come back into the system. I would like them not to come back into the system. I would be happy if my office did not need to exist anymore, there was no crime in the world. It would make me very happy. But if I can help the clients stay out of the system by getting the help and treatment they need, that is important. And I wanted to thank you for, we've talked about a lot of different things over the years, and it was important for you to know that I appreciate you allowing me to use the case manager funding and to hire someone, and I think that will be helpful to the community and obviously to my clients. So thank you.
Well, thank you, Marcy. I know that you work very hard on behalf of all of us. We appreciate it, and you had pre-warned me that you had a lot on the agenda today, and we recognize that it's a few months of a catch-up. So I wondered if anyone had any comments, questions? Supervisor Leggett?
Thanks, Chairwoman. Marcy, is there an ability to follow trend over time with this case manager, and if it's going to make any difference?
We would always be keeping statistics and seeing what the person is working on and what they're doing. So I will be able to report back in the future. I think it will take me a little bit of time to figure out. There is no specific requirement of exactly what they need to do. We're going to tailor it to the office, and so when you have 8 attorneys working together, there are going to be a lot of demands on this person, but I think it'll be really good for the office and the community.
Supervisor Driscoll?
Thank you, Madam Chairman. I also appreciate the holistic approach to it because it also identifies the needs of family members,
Yes.
spouses, children, and their needs being addressed. So
Yes.
thank you.
So thank you very much. I appreciate everybody's time.
Thank you. And at this point, are there any other items to discuss? I think the discussion items we can move over maybe to next month if that works for you,
Sure,
Marcy.
that's fine.
And we'll, obviously, we'd love to be able to hear from you on that monthly basis as well. Is there a privilege of the floor this time? At this time? No? Any other items to come before the committee? I think it's appropriate now at this time to ask for a motion to adjourn.
Sure.
Made by Supervisor Scheffler, seconded by Supervisor Beatty. All those in favor?
Aye.
Opposed? Thank you.